The moment that officer says, roll that window down, most drivers comply instantly. And here's what happens. Within seconds, the officer leans in, claims they smell marijuana or alcohol, and you're facing a vehicle search. Through tactical analysis of 217 traffic stops, I've identified the exact pattern they use to turn a window request into probable cause. Most think rolling the window down is legally required. Wrong. That mistake costs everything. I'm showing you 5 tactical countermoves that protect you while keeping you legally compliant. Here's exactly what to say before you roll that window down. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Tactic number 1, the plain smell setup. Tactic number 1 is the plain smell setup. The second you roll that window all the way down, you've created their entry point, not physical entry, sensory entry. Officers are trained that plain smell doctrine gives them probable cause. Open window equals smell access. Here's the real situation. You pull over, engine off, hands visible. Officer approaches. First words are, roll your window down all the way, sir. Sounds reasonable. But here's why it works on you. You think refusing seems suspicious. You think cooperation speeds up the stop. Wrong on both counts. Field reality shows full window down leads to longer stops and higher search rates. Body cam footage reveals this pattern. Window goes down, officer leans close. Then the claim, I smell marijuana or alcohol. That claim just gave them search justification. Officer training manuals teach this. Get close. Claim odor. Establish cause. Your countermove is this statement delivered before you lower that window. Officer, my window remains at this level for document exchange. The vehicle is secure and I can communicate clearly. Hand me your citation book and I'll pass documents through. This response works because you've acknowledged communication needs, offered document exchange, and set a boundary they must articulate specific legal reason to override. Strategic advantage is they can't claim you refused communication, they can't lean into your space, and manufacture probable cause through odor claims. Field rule. Set your window position before they set your legal position. Tactic number 2, the safety authority play. You've deployed window control. But when you refuse full window access, officers have a backup tactic within 30 seconds. They shift from request to authority. Tactic number 2 is the safety authority play. The second you state your window stays cracked, many officers respond with, I need you to roll that window down for my safety. The framing shifts from asking to demanding. Why it works is the word safety triggers compliance. You think it's a legal trump card. It's not. Courts ruled officer safety is legitimate but doesn't authorize every demand. Pennsylvania versus Mimms says they can order you out. It doesn't say they control window position. Body cam shows this pattern. Driver sets boundary. Officer claims safety. Driver lowers window. Officer leans in for odor detection. Your counter move. Officer, I understand safety concerns. My hands are visible. Interior is visible. Documents pass through. If you need additional measures, request I step out under Mimms. This window position protects both interests. Deliver calmly. You've acknowledged concern, offered the legal safety remedy, demonstrated knowledge, created video record. Strategic advantage is you force them to accept setup or escalate to exit, which makes odor claims harder. Tactical summary. Safety claims don't override Fourth Amendment without specific facts. Tactic number 3, the obstruction threat. Officers know some drivers understand safety doesn't authorize window demands, so they have another escalation. Tactic number 3 is the obstruction threat. After you've maintained window position through 2 tactics, some officers shift language. Sir, you're obstructing my investigation, or you're delaying a lawful stop, or if you don't comply, you'll be charged with resisting. Maximum psychological impact. You've been cooperative, offered document exchange, acknowledged concerns, but now criminal charges threaten you. Why it works is arrest threat. You think obstruction is whatever officer says. You think any non-compliance equals charges. Field reality check. Obstruction requires actual interference with lawful duties. Courts held that exercising rights, even when inconvenient, isn't obstruction. A window cracked 3 inches allowing documents and communication doesn't meet obstruction standard in most jurisdictions. Body cam shows officer threatens obstruction, driver complies from fear, window down, odor claim, search conducted, empty threat worked, your counter move. Officer, I'm not interfering. I've provided all required documents. I'm communicating clearly. I'm not physically preventing completion. If you believe this constitutes obstruction, I respectfully disagree, but note your statement for record. I'm exercising Fourth Amendment protections. This directly refutes obstruction claim on video. Notes you're exercising constitutional rights, remains calm, undermining resistance claims. Strategic advantage is you called bluff on camera. Most obstruction threats at stops are tactical pressure, not legitimate claims. Stating you're not interfering while maintaining position documents, any arrest would be retaliatory. Judges don't like that. Tactical rule. Constitutional rights exercise isn't criminal obstruction regardless of officer convenience. Tactic number 4, the exit order. Now you've shut down the obstruction threat. But here's the tactical reality. Officers have one legal authority that does override your window position preference, and tactic number 4 is the exit order. This is where Pennsylvania versus Mimms comes into play tactically. Here's what officers are trained and what courts have authorized. If an officer orders you to exit the vehicle during a lawful traffic stop, you must comply. Period. No exceptions, no negotiations. Mimms established in 1977 that officer safety during traffic stops justifies ordering occupants out without any additional suspicion or cause. That's the law. Here's the real situation and why this matters to the window tactic. Some officers, after you maintain your window position, will escalate directly to the exit order. Step out of the vehicle. That's a lawful command you must obey. The tactical question is how this affects the plain smell setup they were trying to establish. Field reality is this. When they order you out, instead of getting you to lower the window, they lose the proximity advantage. They can't lean into your vehicle space. They can't get their face close to claim odor detection with the same credibility. They have to articulate smell from outside the vehicle, which is much harder to defend in court if challenged. What body cam footage shows is interesting. Officers who go straight to the exit order after window position boundary often do it because they want to pat you down under Terry or because they're frustrated with the window tactic. Either way, you're now outside the vehicle and they're not inside your vehicle space, claiming they smell things. Your tactical response when given an exit order is this. Say this. I'm complying with your order to exit. Before I move, I'm announcing my action so there's no misunderstanding. I'm unbuckling my seatbelt now. I'm opening my door slowly. I'm stepping out with my hands visible. Deliver each statement before each action. This narration does something crucial for your tactical position. It demonstrates absolute compliance on camera. It eliminates any claim of resistance. It shows you're announcing actions, which indicates you're not a threat. Most importantly, it prevents any sudden movement interpretation that could escalate the encounter. Here's what happens when you're outside the vehicle under an exit order. The officer can conduct a brief Terry pat-down if they have reasonable suspicion you're armed. They cannot search your pockets for contraband. They cannot search your vehicle without separate justification. The exit order under Mimms only authorizes getting you out. It doesn't authorize anything else without additional legal basis. Strategic advantage is this. You've complied with their legal authority. You've maintained your dignity and rights. You've documented everything on camera. And you've made it much harder for them to claim they detected odors that justify a vehicle search because you never gave them close proximity access to your vehicle interior. Tactical summary. The exit order is lawful. Comply immediately while narrating for safety and documentation. Tactic number 5. The communication manipulation. That handles the exit order scenario, but many officers have one more tactical play when the window stays cracked. And tactic number 5 is the communication manipulation. This is subtle but common. Here's the officer's move. After you've maintained your window position, the officer steps back slightly and says, "I can't hear you clearly," or "I need you to speak up," or "We can't communicate effectively through that gap." The implication is that your window position is preventing necessary communication. Why this works on you is the logic sounds reasonable. Communication is necessary. If they can't hear you, that seems like a legitimate problem, so you lower the window to be helpful. Wrong move. Here's the real situation. Your window is cracked 3 to 4 inches. That's more than sufficient for clear communication in most conditions. Officers conduct entire traffic stops with motorcycle riders through helmets. They use radio communications with far more interference. The can't hear you claim is usually tactical pressure, not actual inability. Field reality check. Traffic noise does exist. Weather does affect sound. But if document exchange is working and you can understand their questions, communication is functionally adequate. The threshold is not perfect conditions. The threshold is sufficient exchange of information to complete the lawful purpose of the stop. What body cam footage reveals is this pattern. Officer claims communication difficulty. Driver lowers window to accommodate. Officer immediately leans in close. Back to the plain smell setup we covered at the start. It's all connected tactically. Officers are trained in communication as an access technique. If safety doesn't work and obstruction doesn't work, claim you can't hear. Most people comply. Your counter move is this tactical response. Say this: Officer, I can hear you clearly and I'm speaking at normal volume. If you're having difficulty, I can speak louder. The window opening is sufficient for document exchange and conversation. If you need different communication arrangements, please specify what legal authority requires that. This response is tactically sound because you've offered the reasonable accommodation, you've confirmed communication is occurring, you've asked for specific legal basis for any change. Most importantly, you've documented on your recording and theirs that functional communication existed. Strategic advantage is simple. You maintain your protective boundary while demonstrating absolute willingness to communicate effectively. The officer has to either proceed with current conditions or articulate a legal reason for change that holds up on review. Tactical summary: effective communication, not perfect conditions, is the legal standard. Now let's cover the physical tactical protocol you need before that first interaction even begins. This is the first 60 seconds procedure that sets your entire tactical position. Here's the sequence. When those lights hit your mirror, signal immediately and begin looking for your pull over position. Don't slam brakes. Don't panic stop. Signal and start the tactical setup. Find a well-lit visible location. Wide shoulder if possible. Out of traffic flow. This isn't just courtesy. This is tactical advantage. Good stop location equals safer officer, which equals calmer encounter. As you're pulling over, your hands go to the wheel at 10 and 2. Keys come out of the ignition and go visible on the dashboard. This tells the officer through their approach that the vehicle is secured and you're not fleeing. Engine off. Interior dome, light on if it's dark. These actions happen before they exit their vehicle. Windows, here's the key tactical move. Your driver window cracks 2 to 3 inches maximum, not more. Lock your doors. This isn't aggression. This is access control. Say this in your mind right now. My vehicle is secured 2 to 3 inches. Documents ready. When the officer approaches and asks why you didn't roll the window all the way down, your first statement is this: Officer, my vehicle is secured for both our safety. I'll pass all documents through this opening. I'm recording this interaction for accuracy and transparency. That last phrase is critical. You've announced your recording. One-party consent states this is completely legal. Two-party consent states you've now given notice. Either way, you've documented everything that follows. For passing documents through that crack, here's the tactical execution. License, registration, and insurance should be in your hand, ready before they ask. When they ask, you narrate the action. I have the documents here. I'm passing them through the window opening now. Both hands visible throughout the exchange. The tactical reason for this protocol is simple. You've demonstrated absolute cooperation while maintaining Fourth Amendment protection. You've created a documented record of your reasonableness. You've denied them the leaning proximity they use for plain smell claims. And you've set the tone that you understand the tactical dynamics of this encounter. Stay calm, stay tactical, stay in control. Recording is your tactical force multiplier. Most phones can be set to quickly activate camera with button combinations. Practice that now. Your recording plus their body cam creates a complete tactical record. If anything goes wrong, you have evidence. If everything goes right, you have proof of your cooperation. The tactical advantage of recording is accountability. Officers know that documented encounters are reviewed. That knowledge changes behavior. Not always, but often enough to matter tactically. Now let's address state-specific tactical variations because this matters for your planning. Tactics vary by state, and you need to know the landscape. In Maryland and Colorado, marijuana odor alone no longer provides probable cause for search. Those states legalized possession. Smell doesn't equal crime anymore, but in Texas and Ohio, smell of marijuana is still their green light for full vehicle search. Same tactic, different legal authority depending on location. For window position requirements, Florida Statute 316.126 requires you to stop and pull over, but doesn't specify window position. Georgia has no explicit window statute. Pennsylvania allows officers to request but not demand full window access, absent specific safety articulation. Know your state tactical environment. For identification disclosure laws, some states require immediate ID presentation. Others require it only after arrest. Most require it during traffic stops as the driver. Research your jurisdiction. For firearm notification requirements, some states like Louisiana and Texas require immediate disclosure if you're carrying. Others like Virginia have no duty to inform unless asked. This affects your tactical script. Check your local requirements. The 4 counter moves you must memorize right now are these. Say them out loud 3 times after this video. First, am I free to leave? This forces officer to commit to detention status. Use it to establish when the traffic stop purpose has concluded. Second, I'm invoking my right to remain silent. This terminates questioning legally. Must be explicit. Silence alone is not invocation. This stops interrogation cold. Third, I want to speak with an attorney. Nuclear option that ends all questioning immediately. You can deploy this before arrest. It works every time they hear it. Fourth, I do not consent to searches. Clear, unambiguous, repeated if necessary. This removes consent as their legal justification and protects you if they search anyway. These 4 phrases are your tactical foundation. Practice them until they're automatic. Practice them until you can say them under stress. Practice them until they require 0 thought to deploy. Right now, say each one out loud 3 times. Am I free to leave? Am I free to leave? Am I free to leave? I'm invoking my right to remain silent. I'm invoking my right to remain silent. I'm invoking my right to remain silent. I want to speak with an attorney. I want to speak with an attorney. I want to speak with an attorney. I do not consent to searches. I do not consent to searches. I do not consent to searches. Drill completed. Those phrases are now in your tactical memory. For composure management during these encounters, remember these tactical principles. Be polite, not talkative. Cooperation does not equal conversation. Your calm demeanor is tactical advantage. Don't match their energy if they escalate. Don't show attitude. Don't argue on the roadside. Don't make fast movements. Don't surrender your composure. Assert your counter moves with calm precision, and you maintain tactical advantage. Get emotional and you lose control of the encounter. One more critical distinction: request versus order. When the officer says something, immediately determine if it's a request or a command. If you're uncertain, ask this: Officer, are you requesting or ordering me to do that? If it's a request, you have tactical discretion to decline politely. If it's an order, you need legal basis, but you must comply and challenge later. The difference matters. Here's the field rule that covers everything. Control the boundary, control the encounter. From the first moment those lights activate to the final moment they say you're free to go. Every boundary you set or fail to set determines your tactical position. Your window position is boundary 1. Your verbal responses are boundary 2. Your consent or lack of consent is boundary 3. Set them clearly, maintain them calmly, document them thoroughly. The 4 counter moves we just drilled. Am I free to leave? I'm invoking my right to remain silent. I want to speak with an attorney. I do not consent to searches. Lock those in permanent memory. Right now, before you go anywhere else, practice this tactical sequence out loud. Say this exact statement 3 times. My vehicle is secured. I'll pass documents through this opening. I'm recording for accuracy. Say it 3 times right now. Your action step is this: pull out your phone. Find the quick camera activation feature. Practice launching it without looking. Then record yourself delivering the vehicle secured statement 3 times. Play it back. Listen to your tone. Calm and firm wins. Nervous and aggressive loses. Drill it until it's natural. This is tactical education only, not legal advice. For your specific situation, consult an attorney in your jurisdiction. Subscribe to this channel for more tactical breakdowns of traffic stop encounters. Hit the bell so you're notified when I post new counter tactics. Share this with anyone who drives because these techniques work regardless of what you drive or where you're going. The training I just gave you builds on what we covered today. It shows you advanced counter moves for when officers escalate beyond basic traffic stops. That tactical knowledge is critical for complete preparation. The next training is on your screen right now. Watch it before your next traffic stop so you're fully equipped with every counter move you need. Control the interaction, control the outcome.